Okay, I'm going maybe I came and talked. You were there in the lecture. Okay. Sit down. You want that I give okay. See, very, very nice. How many years?
Good evening, everyone.
Okay.
If I'm audible, every year, PUDR organizes the Dr. Ramanadham Memorial Lecture on a theme that speaks to democratic rights. We choose topics that reflect our own areas of work, but also those that carry wider significance. Today, at the 40th Annual Ramanadham Lecture, we have with us Dr. Namita Wahi, Founder Director, Land Rights Initiative, and Senior Fellow at Center for Policy Research, to speak about questions on land, property, and democratic rights. Dr. Ramanatham's life and work continues to remind us that the struggle for democratic rights is inseparable from the struggle for dignity, livelihood, and justice. He tried to create a space for democratic values wherever he went and in whatever he did. Dr. Ramanatham's involvement with civil liberties was inseparable from his professional role as a doctor. As Vice President of the Andhra Pradesh Civil Liberties Committee, he spoke out fearlessly against state repression, custodial violence, and fake encounters. Struggling against corrupt medical practices in a health center in Hasnabad, helping friends to bring out a revolutionary literary journal in Warangal, organizing a people's clinic with the help of doctors on strike in front of Warangal Government Hospital are examples of Dr. Ramanatham's involvement and initiative in democratic concerns. On 3rd September 1985, Dr. Ramanathan was shot at point-blank range outside his clinic. Though his life was brutally cut short, his commitment to democratic rights and civil liberties continue to inspire activists, reminding us that effective transformative action requires not just resolute commitment, but also a perspective that is centered around the struggles of the marginalized. It is in this spirit that we turn to the question of land rights. Land has always been more than property. It is the foundation of livelihood, identity, and survival. PUDR's investigations over decades reveal how questions of land are tied directly to questions of people's rights. From documenting the displacement of thousands of families in Gopalpur, Odisha, for a steel plant to uncovering the social boycott faced by Dalits in Bagana, Haryana, when they asserted their claim to village common land, PUDR has consistently shown how the promise of legal rights is undermined by the realities of power and discrimination. Recent reports from Punjab echo the same story. Panchayati lands earmarked for Dalit households being cornered through proxy bidders, leaving the landless once again excluded. In every such case, the struggle over land becomes a struggle over dignity, access, and belonging. What these reports showed us is that these struggles cannot be understood merely as disputes over compensation or acquisition. They go to the heart of democratic participation. Whose voice counts when land is acquired? Who decides when forests are diverted or common lands leased out? How are Adivasis, Dalits, and women, those most dependent on land yet least represented in power, treated in these processes? These are not abstract questions. They are the lived realities of people whose very survival depends on whether their rights to land are acknowledged. Dr. Ramanatham's life was a testament to the belief that democracy is not measured by lofty constitutional phrases, but by whether people can live with dignity, security, and justice. To speak of land rights in his memory is to affirm our commitment to this democratic mandate. As we begin today's lecture, let us hold on to two things. One, that land is not merely a resource, but a site where questions of equality, justice, and democracy converge. And two, that to remember Dr. Ramanathan is not only to recall his courage, but to renew our own responsibility to stand with the struggles of those who continue to fight for the rightful share of land, livelihood, and dignity. I now invite Dr. Manoranjan Mohanty, retired professor of political science at Delhi University, advisor and executive member of People's Union for Democratic Rights, to chair the panel.
You should sit here. And no empty chair, please. Friends, it's a great privilege. Friends, it's a great privilege to be present here today and also chair this event. I'm very happy that I'm meeting Namita Wahi for the first time. I've heard about her work, but never had the chance to meet her, so I'm delighted. I think I'm the oldest person in this room. I don't know who else has had the privilege of meeting Dr. Ramanadham. Anybody else? Harish is not around. I don't think. No, yeah. And in fact, my last meeting with him, I met him many times between 1978 and 1985. And my last meeting with him was in April 1985 itself. What a year. And he saw me, Balagopal, Murali Manohar, Sitaram Rao, Ramulu, 6 of us. He saw us off in the bus to Nirmal, and then the rest of the story I will not depict. You have to read about the Adilabad incident. I've written it in my tribute to Balagopal. And after all that happened in police custody, etc., we had to go straight to Hyderabad, and therefore we didn't have a chance to go back to Warangal. That was the original plan. Otherwise, I would have met him again. That was April, and September, this happens, 3rd September. And by then, he was, I think, what, 53 or 56, something like that, in his early 50s. And he was so active as the vice president. Kannaviran was the president of the APCLC, and he was the vice president. And we had done a lot of activities together there, and QDR and APCLC have done many investigations together. And that particular trip of mine and Balgopal, etc., we were going to Indravali, where the members of the Pirijan Rights Sangam, the tribal peasants, had been killed. And therefore, every year in April, there was a memorial in there. They were killed because they were protecting their land, which was being taken over by deforestation and eviction by the state to locate some factory. So the Indravali firing and the Indravali, we have the report on the Indravali investigation. First, it was published in mainstream, and it may be in our website. So, for the land question and Ramanathan, and so what a coincidence. I'm present here still to say something about this. So Ramanathan is a symbol. I mean, soon after that, PUDR and APCLC and many other civil liberty groups decided to celebrate this, observe this as Civil Rights Day. So we observe this as Civil Rights Day in India. And that's why every year, 3rd September, we organize this. And some years we are not able to organize in the same day, but around the day. On the topic, I have just one brief point to make. I look forward to listening to Namita. PUDR reports on land question are many. And the common theme is that for poor people, for the landless and small peasants, land is an extremely important resource. Therefore, land right is a people's right because in two ways this has been attacked. One, common land has been taken over, and we have so many reports in Orissa, in Bihar, so many, particularly Arwal, and many common land cases. And now Punjab, the Punjab land being taken over, the latest PUDR investigation. So what? Because common land is either used for cultivation or in habitation or various things by a lot of poor people together or a whole community, village, and so on. But the other thing is that after common land has been sort of possessed for decades by poor people, as we saw in Posco area and many other places, then suddenly the state discovers, or the occupation forces, these big industrialists are occupation forces. Occupation forces discover that this land didn't belong to them. They are illegal encroachers on this land. You see, and state and big business then evict them. We saw it in, in the Panbaras areas, in Posco area. Now Posco is gone, but Jindal is doing exactly the same thing, and the movement is going. And there are many PUDR reports are, they're full of these. Therefore, the law, they don't have patta. They for 100 years, or 75 years, they have been, or more, they have been in occupation. And so they never thought that this will be a situation coming. So suddenly, there is the demand. The state says, show us your land records. Now, therefore, and therefore on the property question, I don't want to take any more time. The right to property was abolished to protect the Jamindari abolition laws. Okay, so that's the context. So land as property and land as a basic resource, as a right of poor people. You have to see the context and the political economy of the land right. That is most important. And that's why this is an extremely important question. And now the state and the big business, they are on a spree of taking over land, clearing Chhattisgarh, clearing Odisha, Koraput, Balangir, Niyamgiri, all those areas, just to enable Adani, Ambani, and other big business forces to have mineral projects, other different projects. And so that is the context why land question is so important to have a national discourse, a national political discourse on the land right of common people, land right of ordinary citizens. I think this question has to be opened and discussed all over. And I'm so glad that this year we have an expert and we have an occasion to emphasize this topic. Thank you very much. I now call upon Namita Wahi to make her presentation.
Should I just move here? Is that okay? Yes. Is it working? Yeah. Can you hear me? Yeah. Hello, can you hear me?
Yeah.
That's good. Good evening, everyone. Thank you, Professor Mohanty, for chairing the session and for your warm words of appreciation. It is a tremendous privilege and honor for me to stand before you to give the annual Dr. Ramanadham Memorial Lecture. And I want to thank Lawrence, Shahana, Harish, and others at PUDR who reached out and helped organize this lecture. As was mentioned by Angela, Dr. Ramanathan's life has shown us that civil liberties and democratic rights are as important to the survival of a nation and its citizens as the very oxygen that we breathe is important for our survival as human beings. The ability to freely elect our representatives to govern us, alongside the ability to think, speak, act, and live freely in fraternity with our fellow human beings, and to contribute to our mutual prosperity, is what emancipates us from political, economic, and social subjection and transforms us from subjects to citizens. The concept of property has been crucial to our understanding of civil liberties and democracy, even as land as a form of property has been the most important source of food, livelihood, shelter for human beings across centuries, and is also intrinsically connected to individual and community identity, history, and culture. 75 years ago, India became a republic when we adopted our constitution, and 350 million Indians, both men and women, went overnight from being subjects of the British Empire to becoming citizens of the Republic of India. Property holders, mostly men, drafted the Indian constitution over a period of 3 years. The reason I say this is that the people who elected the Constituent Assembly, there was a property qualification. The constitution that was ultimately drafted, however, guaranteed to all citizens, men and women, the right to hold, acquire, and dispose of property. At the time the constitution was adopted, 80% of Indians depended upon land for their livelihoods. Today, 75 years later, 60% of Indians still depend upon land for their livelihood. According to Land Conflict Watch, over 10 million Indians are affected by on-ground conflict over land, which spans millions of hectares and threatens investments worth $3.45 trillion. And the numbers are only increasing as Land Conflict Watch has continued to map conflicts. A few years ago, the number was only half of this. So it's not so much that the conflict is increasing, which is also true, but also that we haven't mapped and we haven't created enough research on the subject. Land disputes clog all levels of courts in India, accounting for the largest sets of cases in absolute numbers and judicial pendency. A constitution as massive as India's is surprisingly sparse in its reference to land. Spread over 395 articles in 22 parts and 8 schedules at the time that it was adopted in 1950, the original Indian constitution mentioned land in only 4 parts. First, in part 3, with the reference to the now abolished fundamental right to property that Professor Mohanty also referred to, embodied in Articles 19(1)(f) and 31, which recognized the right of all citizens to acquire, hold, and dispose of property, and provided constitutional safeguards against the exercise of the state's power of eminent domain. The state's power of eminent domain allows the state to take away property belonging to private individuals for the public good, pursuant to a validly enacted law for a public purpose and upon payment of just compensation. So that was the first reference, Fundamental Right, Part 3. The second was in Part 10, read with the 5th and 6th schedules to the Constitution, while referring to geographically demarcated areas for scheduled tribes called scheduled areas. At the Land Rights Initiative, for the first time, we mapped the scheduled areas. The government of India had never created a map of the scheduled areas. We mapped them, and we can tell you that over 13% of India's geographical area falls within scheduled areas in 14 states today, including Adilabad that Professor Mohanty mentioned. And interestingly, when I started work on the Land Rights Initiative, the first state I worked in was Andhra Pradesh. And in Hyderabad, I met Kalpana Kanabaran as my first set of interviews with key informants there, and learned a lot about the issues. And we've worked in Andhra since then. So learned about Balagopal and the contributions of all the people you mentioned at that time. That was in 2015. Third, in Part 11, read with the 7th schedule to the Constitution, with reference to the distribution of legislative powers between Parliament and state legislatures. Land was identified as a state subject, while many subjects pertaining to land were included in the concurrent list on which both Parliament and state legislatures can legislate. The Land Rights Initiative's Mapping Indian Land Laws project, available at landlawsofindia.org, is the first such attempt to compile an interactive exploratory archive of all land laws, active central and state land laws pertaining to land. And we have done this for the center and 8 states. And I can tell you that there are over 500 laws on that website just for center and 8 states, including Andhra Pradesh and Telangana. And finally, in the succession clause embodied in Part 12 of the Constitution, which provided for the Indian government's succession to all obligations and entitlements of the British government with respect to contracts, property, and assets, including land. And this is particularly relevant to the issue that also Professor Mohanty raised about common lands, because if we go back in history to the work of Baden-Powell, if you read his 3-volume treatise on land systems in British India, which is still cited by the Supreme Court as an authoritative text on land where there isn't developed legislation or case law, the British government made this very, and I've talked about this in this paper I have on property and sovereignty, creating, destroying, and resurrecting property rights in British India from 1600 to 1800, where I talk about how the British government basically in the permanent settlement to begin with really destroyed the existing arrangement of property rights, where land was something on which multiple groups of people exercise different kinds of property rights, and rather said that, the British government was the ultimate landlord, and the zamindars, they created a class of zamindars, but also the zamindars could also only keep their land so long as they paid revenue to the crown. So they really transformed those property relationships. And because the Indian government succeeded to that colonial, relationship, except as Article 13 says that laws that are not consistent with fundamental rights, but we retain that entire architecture, and only insofar as courts pronounce a law to not be consistent with fundamental rights can those laws be abridged. But that's and if we in the Mapping Indian Land Laws website, of the 500 laws that we have put there, 150 are colonial laws, which are still active, and 350 are post-colonial laws. So these past references to land in the original Constitution are somewhat surprising for 2 reasons. First, as I said, at the time the Constitution was drafted, an estimated 80% of all Indians were dependent on land for their livelihood, and more than half of India's GDP came from agriculture and allied rural occupations. Second, not only had land conflict punctuated 200 years of British rule in India, but land had also been central to the independence movement struggle to establish a new social and economic order premised on rapid economic development and social redistribution, even as Indians sought to control their political destiny. So first of all, what do I mean by property? Property, as we lawyers understand it, is a bundle of rights. It includes rights to title or ownership, but also includes rights to use, possession, transfer, mortgage, inheritance, and lease. And these rights are all property rights. And therefore, the right of the title holder is not necessarily superior to any of the other rights. They are all property rights, and they are configured in different ways, in different places, in different periods of time. But if we look into what is the relationship of property to democratic rights? So going back to liberal political theory, starting from theorists like Hugo Grotius, Thomas Hobbes, John Locke, property or ownership was constitutive of individuality, freedom, and equality. To be an individual, according to these theorists, is to be an owner. In the first instance, an owner of one's own person and capacities, but also of what one acquires through the use of those capacities. So, Locke's famous labor theory of value, you mix your labor with the land, and only then can you claim property out of it. If the land is not being cultivated, then it's not really property. And that's why it justified grabbing the indigenous people's lands because they were not practicing settled cultivation, right? So according to liberal political theory, freedom was equal to independence from others, and independence arises from the right to use one's property. Equality was also linked to ownership because being an owner of one's own person and capacities is a status that every individual enjoys equally. So that's how property constitutive of ownership connects to liberty as well as equality. However, critical theorists like Rousseau and Marx decried the illegitimacy of this social contract that these free individuals come together to find, because we know that, as they famously said, man is born free, but everywhere he's in chains, right? So this concept of a utopian freedom never really existed. And they critiqued the idea of the liberal individual as an individual monad. According to Marx, man is a species being. And from this conception arose the idea of the social function of property. Rousseau understood property as a relational thing created through an illegitimate social contract that preserved inequalities as opposed to being derived from the state of nature. And Marx critiqued liberal rights as not emanating from the state of nature, but as a result of historical struggle against privileges bequeathed from one generation to another. The practical application of the right to liberty, according to Marx, is the right of private property. And the right to property is the right to enjoy one's fortune and to dispose it off as one wills without regard for other men and independently of society. Therefore, the right to property is really the right of self-interest. And the right to equality is the equal right to liberty. So the right to equality is the equal right to liberty, and liberty is nothing but the right to property, and right to property is nothing but self-interest. Therefore, these rights are actually not really conducive to the social good or to the evolution of man as a species being. Apart from these discourses on liberal rights, there was a discussion of there were some discussions about property in the post-World War discourse on economic development. In the 1940s, for the first time, there was this belief that based on what had happened also in the Soviet Union since the 1920s, that if that development could be planned, that there were ways and things that we could do, the state could do, as most of these countries that were former colonies were emerging from colonial rule. There was this belief that development, which was equated at that time with poverty alleviation and raising the standards of living of the people, it could be done through capital formation and the associated concepts of planned industrialization, big push and balanced growth. So some of the authors mentioned here, Rosenstein, Rodan, the Prebisch-Singer hypothesis was really about the fact that developing countries are poor because the terms of trade are not in favor of them because they are primary products producing countries, but we need to have planned industrialization, capital formation. And this dominated discussions in development theory. And the result of these discourses on actual policy and theorists who were talking about land was really this focus on land reforms. And again, within these land reforms, literature, like apart from the fact that zamindari should be abolished, there was not enough consensus about what's the way forward. Alfred Marshall was someone who spoke about the fact that we should have larger farms because beyond a point, smaller farms will not be productive. But people like Alexander Chainov, who wrote the book on the theory of peasant cooperatives in India, Charan Singh, wrote about the fact that land reforms and small farms are productive, and that is the way that India should go. And we should remember that Gandhiji was also talking about this. So what was the impact of these discourses on us? First of all, we adopted a constitution guaranteed to ourselves both fundamental rights, rights of liberty, equality, and property, but also the directive principles of state policy in Part 4, which took into account the critiques that had been made of liberal political rights by the critical theorists. What we also did is that we passed a series of land reform laws in the 1950s. This is a snapshot of the Mapping Indian Land Laws website available at landlawsofindia.org. You can search these laws according to various methods, geography, category, time period. Here, I'm just showing you a snapshot that there are 125 active land reform laws on the website right now. And if you see, they relate to abolition of zamindari as it's classified as abolition of intermediaries here because zamindari was one form of intermediary, but there were others, but also tenancy reform, land sealing and redistribution, consolidation of holdings, and so on. And generally, this was, the prescription for land reform. There was no particular focus on property rights. So land reform was there, but not a particular focus on property rights as a part of economic development. That, however, changes in the neoliberal economic discourse, starting with the work of Douglas C. North and scholars that are loosely grouped under the rubric of new institutional economics, an interdisciplinary program of lawyers, economists, and other social scientists who offered a variety of arguments on behalf of the need for formal property rights to promote economic growth. And then we have Hernando de Soto, who in the 90s in his book, The Mystery of Capital, said that, the poor are poor because they don't have property rights, that strong, secure property rights are a necessary precondition for economic development. And finally, last year, the Nobel Prize winners in economics, Darren Acemoglu, Simon Johnson, and James Robinson, took this work forward and, basically said that inclusive institutions and democracy are essential for economic growth. By inclusive institutions, they include within that secure property rights. So from the 1940s post-World War discourse, where there was a focus on land reform, but not property rights specifically, now the development discourse has shifted in 1980s onwards to really have a strong focus on property rights. And what does that mean? But let's now go back to our constitution and look at the original constitutional compromise on fundamental rights and directive principles of state policy. The reason I call it a compromise is because the debate on fundamental rights and directive principles went on for a long time, but the debate on the right to property was one of the most contentious, the second most contentious, according to Granville Austin in the drafting of the Constitution. The only thing that was more contentious was the list of official languages. So what did we come up with? The Indian Constitution represented a commitment on behalf of we the people to be governed by elected representatives according to the rule of law. And part 3, guarantee to all citizens fundamental rights to life, Article 21, liberty, Article 19, equality, 14, and property, 31. These rights were subject to reasonable restrictions in the public interest, and any law which violated fundamental rights would be unconstitutional. Apart from that, we had what they call non-enforceable directive principles of state policy. The first was to transform us from political subjection to make us citizens from subjects. And these principles were to essentially raise us from economic subjection. So they talked about distributive justice and social control. Article 38 says the state shall promote the welfare of the people by securing a social order in which justice, social, economic, and political shall inform all institutions of national life, and that the state shall strive to minimize inequality in income and endeavor to eliminate inequalities in status, facilities, and opportunities amongst individuals and groups. And the state shall direct its policy towards securing that the operation of the economic system does not result in the concentration of material wealth and means of production to the common detriment, and that ownership and control of material resources of the community are so distributed as best to subserve the common good. So the original constitutional compromise was that all of this are important, but because fundamental rights were enforceable and these were non-enforceable, therefore fundamental rights were superior in that sense to the directive principles of state policy. The DPSP also included a right to livelihood and living wage. Men and women shall have the right to an adequate means of livelihood, equal pay for equal work, and the rights to work, education, and public health assistance in the case of unemployment, old age, sickness, or disability. Now we come to how property fit in within the scheme. As we know, it was in the fundamental rights chapter, so it was enforceable. It was one of the most debated provisions. It was the most amended fundamental right. It's the only fundamental right to have been abolished. So they never got it right, right? And what was the right to property? Articles 19(1)(f) and 31 said that 1901F was an empowering dignitarian provision which essentially said all citizens shall have the right to acquire, hold, and dispose of property. And the state may impose reasonable restrictions on the exercise of the right to property in the public interest. Article 31 was the eminent domain provision, which allowed the state to acquire somebody's property only pursuant to a validly enacted law for a public purpose, and the law must provide for compensation. But the reason why this debate was so contentious was, as Professor Mohanty mentioned, because land reform was crucial, not just to our economic development at the time, but really to our independence, So even as the debate on the Constituent Assembly was going on, parallelly, Nehru, as the first Prime Minister of India, was, the Constituent Assembly was also sitting as a provisional parliament. And they were passing laws, and the most important first laws that were passed, and you see this in the Mapping Indian Land Laws website as well, when you categorize as per time period, the 1950s laws are all about land reforms, and the first most important thing they're passing at this time is the abolition of zamindaris in UP, MP, Bihar, but there are 10 states where they're passing land reform laws. And they wanted to secure that these laws should not be subjected to any kind of setbacks. So what the clause did at the time was that it ousted judicial review of pending land reform legislation, but it was very convoluted. It didn't exactly say these words, but it said that legislation that was pending and excluded laws affecting property rights in the exercise of taxation and police powers from the requirements of compensation. Now, there were two discourses that framed the debate over the right to property. The first was the rights discourse, and the second was the development discourse. Now, in a polity hitherto composed of British colonial masters and Indian subjects, demand for basic rights against arbitrary British rule dated back almost to the founding of the Congress, starting with the Home Rule Bill of 1895 and culminating in the Sapru Committee report of 1945. It was a dignitarian discourse because it was premised on the dignity of each individual to realize their full potential as human beings and equal citizens of newly independent India in a society that was deeply divided on the basis of caste, class, religion, ethnicity, and gender. The development discourse, on the other hand, focused on poverty alleviation and improvement of living standards of all Indians. Development required, according to the development discourse and the Constituent Assembly drafters, a move from a feudal agrarian society to a capitalist industrial society through land reforms, state planning and control of heavy industry, and through encouragement of growth of private industry in other areas. This discourse was a utilitarian discourse, empowering the state to take coercive actions against individuals and groups premised on the philosophy of the greatest good, of the greatest number. So there was an inherent contradiction between the development discourse and the rights discourse. And within this broad overarching rights and development discourses, there were diverse opinions within the Constituent Assembly on what rights should be secured and how development should be achieved. So there's consensus, we want rights, we want development, but what rights and what development, there's a divergence of views. And so the first set of rights they all want, and this is something that everybody is agreed upon, is civil and political rights, because these are all people who spent endless amounts of time in jail for resisting the British rule, right? So consistent with political liberalism to protect the citizen against arbitrary exercise of power by the state, supported by a majority of the Congress leaders, including Nehru, our first Prime Minister, Patel, first Home Minister, Ambedkar, of course, the chairman of the drafting committee of the Constitution. And then they all want social and economic rights as well, consistent with socialist thought and made imperative by the threat of radical communism. As Nehru said on the floor of the Constituent Assembly, if we don't do something to secure these social and economic rights, the communists outside are going to really make sure it happens violently, right? So Congress socialists led by Nehru, Communist Party of India and Ambedkar were really responsible for bringing this focus on social and economic rights. Finally, property rights. Zamindars and industrialists wanted property rights, and many Congress leaders, including Sardar Vallabhbhai Patel and Rajendra Prasad, the first president of India, Sardar Vallabhbhai Patel, the first Home Minister of India, they wanted to secure property rights. And finally, there were those, and I have coined this term of the bottom 60%, who sought to bring about social emancipation from social subjection, not just political subjection and economic subjection of women, Dalits, and Adivasis. I call them the bottom 60% because women were 49% of the population at this time. And assuming that we have the same percentage amongst Dalits and Adivasis, given their percentage, they constitute 60%. They were 60% of India's population then. And we have Nehru, Patel, Prasad, Rajendra Prasad, Ambedkar, and the very few women members in the assembly talking about these issues. Rajkumari Amrit Kaur, Durgabai Deshmukh, they were the ones leading these rights. And then, of course, they also talked about, state land development was focused on industrialization and capital formation. This was, again, a consensus amongst all Congress leaders except Gandhi. Gandhi wanted India to be village republics. He was assassinated. As we all know, the father of the nation was assassinated in 1948 while this debate was still going on. But there were people who carried his views into the debates. Then, of course, there was land reform, but the only consensus that the Congress leaders had, also because they had opposed them politically, was on abolition of zamindari. There was no consensus on how to bring about the rest of land reform. Just zamindars have to go, but how do we do the rest of it? No consensus. So the debate rages on for 2.5 years. And then Adivasis, because of their unique relationship with land and the fact that land for them is central to community identity, history, and culture, here again, there was the dominant Congress narrative, development through integration, as opposed to the British policy of identity-based isolation. I talk about this also in our report on the land rights of scheduled areas, where for the first time we created the map of the scheduled areas, that the British had followed this identity-based isolation to keep them away from mainstream society. The Congress wanted to integrate them. And the only two tribal representatives, their voices were drowned out in the Constituent Assembly, more or less, were Jaipal Singh Munda and J.J. Nichols Roy. But they were very, just two against so many. But essentially, they wanted limited sovereignty or autonomy over that territory. So 10th schedule as they fifth and sixth schedules as they conceptualized it was very different in a way from what the Congress wanted, but the Congress was dominant. And this debate was less contentious precisely because the voices of the scheduled tribe representatives highlighting the special relationship of Adivasis with land and the need for their development according to their own genius and not to be integrated within mainstream society were effectively drowned by the dominant statist and integrationist discourse. Unsurprisingly then, despite being the only group in the constitution with special land protections, scheduled tribes constitute the group that has been most displaced since independence. Of course, discussions on the rights of other forest-dwelling communities, cattle grazers, and fisherfolk, exactly the kind of people who depend on common lands for their livelihoods, are conspicuous by their absence. Instead, the deceptively innocuous succession clause in Part 12 of the Constitution constitutionalized the British state's illegal appropriation of people's lands by allowing the Indian state to take over all land and property claimed by the former. And the least contentious, perhaps, was the debate on Article 19(1)(f), which gave hitherto disempowered groups such as women and Dalits equal rights as citizens to acquire or inherit property, especially in land. So these are the representatives for women, the biggest champion of women and Dalits, and is Dr. Ambedkar, but also Gandhiji, who actually was fully instrumental for bringing women, by bringing women out of the houses into the independence movement. He perhaps contributed as much, if not more, than anyone who worked for the empowerment of women's rights. And these are Jaipal Singh Munda and Father J.J. Nichols Roy, who spoke for the rights of the Adivasis in the assembly. And then not only was it like once they finally agreed that like we are going to have this right, but then there was a lot of discussion on, okay, whether this right should be justiciable, what part of it should be justiciable. And again, there were like different groups within the assembly. Here we have Gandhiji flagged by Nehru and Patel. Nehru didn't want that the courts should be able to review anything. Patel wanted some kind of judicial review. On the left-hand side, we see Dr. Ambedkar, but we also see K.M. Munshi, who was a lawyer and a very important person. And he was the one who was constantly warning us about arbitrary state action and the fact that we should have full judicial review. So there was like these three different groups also, and what compensation should be paid. There was a dispute about that also. So lots of disputes, lots of divergent voices in the Constituent Assembly. And I just want to now talk a little bit about development and its discontents. there has obviously over the last 5 years, India has made remarkable progress in lifting people out of poverty and also ensuring basic rights to people, right? So our population is like 4 times now. We started with 350 million, 1.4 billion. Life expectancy has significantly increased. I mean, the average life expectancy, and that's the greatness of this constitution. I always marvel at it. Like, the average life expectancy in 1950 was 40 years. And the average literacy rate was only 18%. Can you imagine making like a population which has only 18% literacy rate? Everyone has the same rights. It's truly remarkable. And even like Indian women got the right to vote even before all classes of British women got the right to vote. And it's really something that we must celebrate and protect and be proud of. The literacy rate in the population has also increased. We're still not at 100% literacy rate, which is a shame. We should have reached this by now, but we have had this thing. We have seen a rise in the GDP, and you can see that the rise in the GDP was very slow in the first few decades. They used to actually very disparagingly call it the Hindu rate of growth, and then it goes up. Post the 1990s, post liberalization, we have an increase in the GDP. We have a significant increase in the per capita income. Again, it's quite slow in the first few decades, and it's much higher in the post 2000s. What we also see an increase in is the development expenditure as percentage of GDP. Just as GDP figures have risen, so development expenditure as percentage of GDP has also risen from like 3.5% in the 80s to 20% now, right? And yet, if you look at the annual real income growth rate per adult, so we see the red line represents the bottom 50% of the population, and we see that the bottom 50% of the population, even though it has increased the annual growth rate, but the gap has also increased between the full population and the bottom 50%, which means that inequalities have increased. And same for the income growth rate of the top 1% and the top 10% of the population, so the red line. So as opposed to the so this decade of the 70s, nobody's really growing very much in the income, which is why it was such a turbulent decade, and we moved towards socialism, etc. But then, as you see, the top 10%, their income, so it's not just, so there was a time when the top 1% was very separate from the rest of the population. That's not the case. Now it's the top 10%. But the bottom 50%, the inequality has considerably increased. And yet there is a remarkable progress and remarkable economic development that we must celebrate also for this extremely poor country to reach where we are, but lots of gaps and things to do. So now let's come back to the problem with the right to property. Like why was there so much concern about the right to property? Now, it was believed that judicial enforcement of property rights would impede distributive justice goals. So someone like, as Nehru would say in the Constituent Assembly, is that we have to make sure that, the people who have given us this responsibility, that we are actually representing their best interests. And those who lack property or have experienced deprivation of property entitlements are often unable to provide for their basic social and economic needs, and social redistribution programs such as land reform that seek to alter existing property arrangements in order to meet such distributive justice goals and ensure fulfillment of their basic social and economic needs are impeded by enforceable property rights, because it will not be possible for us to do land reform. Now, there was this narrative that the fundamental right to property blocked the uplift of the poor. There was this narrative that there was a reactionary and pro-property rights Supreme Court that impeded land reforms introduced by a very progressive parliament led by the Congress Party and Nehru, right? So I just want to say a few more things about the Constituent Assembly. In 1946, 70% of the delegates in the Constituent Assembly were from the Congress Party. With the partition of India and Pakistan in 1947, 90% of the delegates were from the Congress, because all the Muslim League members left. So suddenly the Congress became dominant. In a way, it always was, but it became even more dominant. Then India opted for a parliamentary system of government with a first past the post system, as a result of which it was much easier for a dominant party to become dominant, right? So a dominant party in the literature is referred to as a party which has durability and incumbency, who exercises power for many terms and commands consistently large majorities of seats or votes. Political parties that have organized freedom struggles against colonial rule often become dominant parties. We are seeing this in South Africa with the African National Congress, right? In the first three national elections that were held in 1952, 1957, and 1962, the Congress won 74%, 75%, and 73% of the seats in parliament. In the 1967 general elections, the Congress's seat share in parliament fell to 54%, and the vote share dropped to 41%. But still above 50%, right? The seat share is still above 50% and the vote share is above 40%. But can you see that the problem with the post system is that the vote share is always less than 50%, always for a dominant party, even when it is commanding 73%, 74%, 75% seats in parliament, even for the Congress, which has had the highest vote share, 45% is the highest vote share any party has had to form government. It has always been less than 50%. And in 1971, the Congress's seat share in parliament rose to 68% and the vote share increased to 43% again. So it remained dominant except for a brief period. And between 1975 and 1977, as you know, during the emergency, the dominant party became authoritarian. So what does this have to do with our story? So coming back to why land reform was contentious, and here, if you see at the top, this is Maharaja Adhiraj Kameshwar Singh of Darbhanga. He was the richest landlord in the state of Bihar, and he was also a member of the Constituent Assembly, and he was one of the people, apart from Patel and others, who actually wanted full compensation and justiciability by the courts on the laws of land reforms that were going to be passed. On the left-hand side, we see the Patna High Court, where this challenge went up even as the constitution was being drafted, where the Bihar land reform law was challenged for being unconstitutional and was found ultimately to be unconstitutional by the Patna High Court because it had a graduated scale of compensation for zamindari. So the bigger the zamindar, the less compensation he would get, and so on. And the Patna High Court found this unconstitutional. Justice Shearer said that this was violative not of the right to property, but of the right to equality. Simultaneously, a challenge goes to the UP and MP laws. The UP High Court in Suryapal Singh versus State of Allahabad actually holds that the law is constitutional. So, very turbulent time, we adopt our constitution. These cases go in appeal before the Supreme Court. 1951 general election going on. Sardar Patel also, he dies soon after. I think 1952 is the general election. And then the issue comes before, and the very interesting thing is, this Parliament building, which is now a museum, actually the Supreme Court was sitting here with the Parliament at this time. So it's really like close. The conflict is really at close quarters, right? But this narrative was put out by Nehru and others who were in Congress leading the charge, essentially saying that the courts are, regressive. They are stopping land reform. And they win the elections in 1952 on this land reforms agenda. And there is this narrative that is created of this progressive parliament and this reactionary court. And it's not until the 1980s that, with the public interest litigation movement and so on, that people say, oh no, now the Supreme Court has changed. Now I'm here to refute this narrative. So let's go on. So in the Kameshwar Singh case that was now before the Supreme Court, the very interesting fact is that the Constituent Assembly, sitting as provisional parliament, it passes a law to amend the Constitution, right, in 1951, and introduces the first schedule, Articles 31A and 31B in the Constitution, and appends the 9th schedule to the Constitution. Article 31A ousts judicial review of land reform laws, including acquisition of estates on grounds of violating fundamental rights, and 31B ousted judicial review of all laws inserted in the 9th schedule on grounds of violating fundamental rights. And so people are saying to Nehru and the Congress that, why are you doing this right now? Why don't you wait till the general elections? Number one. And number two, why don't you wait for the Supreme Court to give its decision in the Kameshwar Singh case? But they say no. They go ahead, they amend the Constitution. And Ambedkar actually supports this. And he's also part of the first cabinet. The first cabinet is the most representative cabinet we've ever had. And he's part of this. This is all going on 1951, 1952. The Supreme Court, however, it upholds the UP and MP laws. I mean, the High Courts had also upheld it. It also upholds the Bihar law, but it still strikes down two provisions in the Bihar law. And that gives it this narrative that the Congress party really puts forth that, the court is reactionary. And that narrative sticks. But in subsequent land reform cases, as I study them, the Supreme Court upheld all land reform laws on grounds that Articles 31A and 31B had ousted justiciability of all fundamental rights. So they upheld land reform laws in the states of UP, Madhya Pradesh, Madras, the state of Bombay. At that time, it was the state of Bombay and Orissa. So, but every time the other cases keep coming before the Supreme Court, the government keeps amending the Constitution. So the First Amendment, the interesting thing though, and this is what I want us to pay attention to, is that Ambedkar, who supports the First Amendment in 1951, is actually a lawyer on behalf of Kameshwar Singh in the Supreme Court in 1952. And that is a clue to what this great man who gave us this very progressive constitution was really concerned about, right? So as we go forward, every time there's a legal challenge, they keep amending the right to property, the 1st, the 4th, the 17th, the 25th, the 44th. And ultimately, the 44th Amendment abolishes the right to property from the Constitution. And then it also, so basically they reversed the original constitutional compromise. And later on, when we have the 1970s, when Indira Gandhi is the prime minister, after the bank nationalization case and the abolition of the privy purses, we have the judgment in Minerva Mills as well, which essentially reversed this constitutional compromise where the fundamental rights are superior to the directive principles of state policy. So let's come back to why did I start to excavate this dead right 15 years ago? Nobody was talking about property rights when I started working on this in my PhD, right? And we had not even learned about it in law school. And I have so many friends from law school here who will probably remember, but I never really learned that we even had a right to property or what it was about in the thing. What happened? So it's from the 1980s onwards, as I said, the development discourse, there was this neoliberal critique of the conventional narrative on property, starting with Hernando de Soto's work in The Mystery of Capital. Strong formal property rights are essential for, unlocking, as you said, economic growth and wealth. The World Bank started pushing for programs for formalization of property rights and, land titles. The Niti Aayog recently came up with, the land titling, a model land titling law, again, a focus on property rights. Simultaneously, and then this has led to several policy and legislative impact of the neoliberal discourse, the entire digitization of land records modernization program, the scheme, the model land titling law of the Niti Aayog. There was a lot of criticism, but Andhra Pradesh went ahead and enacted this Land Titling Act of 2022. This act has actually been stayed by the Supreme Court right now, but we also have the Swamitva scheme. And in India, the thing is, the government really doesn't pass any laws. They just do whatever they want and then they legalize it later, like they did with Aadhaar, right? So there are a lot of these things that are happening just as schemes and policy efforts. And the Alpin, the Bhu Aadhaar, this geospatial, everybody's land is being mapped. We have no idea, drones all over us, doing everything. We have no clue. And then one day they'll pass a law, right? So this is what's been happening because the neoliberal discourse on development placed a focus on property rights. Simultaneously, we have social movements like the Ekta Parishad critiquing state acquisition of land and seeking land rights of the poor and landless communities. And as Professor Mohanty was also mentioning, that there's so much displacement, so much land grabs that has actually happened after the right to property was abolished. And that leads to the property paradox. More inequality and more displacement, more land grabs. And there is also, the development discourse is not a homogeneous discourse. There is a neoliberal part of it, the AJRs, the De Sotos, but there's also Amartya Sen who's talking about development as freedom and the idea of justice, where he talks, and now we are talking about a right to development in international law as well. And what does that mean, right? And there have been the legislative efforts that have come through the work of social movements, organizations like PODR and others who have actually tried to push for the rights of the bottom 60%. So in 1956, the Hindu Succession Act, the reason why Ambedkar resigned from Nehru's cabinet, because the Hindu code was defeated. What he staked his entire work on was the Hindu Succession Act, because it was supposed to finally give equal status to women. And of course, it wasn't enough because, as I mentioned before, the land laws are state laws. So within the agricultural land, there were still discriminatory provisions. Some of them have still not been removed 75 years later. But a lot of work has been done to at least provide equal rights in law, not in practice, but in law to women. and Dalits, and protections, like, for example, the Prevention of Atrocities Act against scheduled castes includes the fact that if their land rights are taken away. And then, of course, for the Adivasis, we have had the Panchayat Extension to Scheduled Areas Act of 1996, along with the Forest Rights Act of 2006. The Forest Rights Act is like the Constitution, very pioneering legislation, which for the first time grants individual and community rights to land. There are very few legislation that do that in many countries of the world. So there have been these other parallel efforts alongside other rights-based legislation that we are familiar with that apply to all of us, right to food, right to education, and so on, which come from this conception of development as freedom that Amartya Sen and others have championed. So this has then also led to people saying that, there was this petition in 2010, the Supreme Court dismissed it, but essentially they were sought to invalidate the 44th constitutional amendment because they said that the right to property, once it went, like people were being displaced left, right, and center. So we need to basically get rid of the 44th amendment, but the Supreme Court dismissed the petition saying that it was not an appropriate case but it was not on merit. So it left the room open for this to be challenged again. And in KT Plantation versus State of Karnataka and Super Cassettes Industries, the court actually reinstated requirements of public purpose and compensation within the meaning of Article 300A. So in a way, the court has actually reinstated the Article 31 property clause that had been abolished in 1978 through judicial precedent, which is what the court does a lot. So the newest episode in the property saga really came about last year. In this case called the Property Owners Association versus State of Maharashtra, and the judgment for the majority was given by Honorable Justice Chandrachud. The petitioners challenged Chapter 8A of the Maharashtra Housing and Area Development Act, which allowed the state to acquire certain properties for redevelopment. This was a momentous decision which turned on the interpretation of whether material resources of the community in Article 39B. If you recall from the Directive Principles of State Policy chapter, it says that material resources of the community should be so organized as to best subserve the common good. And over time, the compromise that had been reached is that in Minerva Mills, that the DPSP will be superior to this concept of property because property had been abolished anyhow, right? So in this case, the court overruled a 50-year precedent that had been set after Minerva Mills in Sanjeev Coke Manufacturing Company versus Bharat Coking Coal, which held that the material resources of the community include private property. So the state can also take away private properties to redistribute for the common good. Writing for a 7:2 majority, Justice DYC held that the interpretation of Article 39B cannot run counter to the constitutional right to property because Article 300A is the constitutional right to property now. The materiality of a privately owned resource and whether it has a community element cannot be determined in a vacuum and must be identified on a case-by-case basis. Some considerations that he put out were the nature of the resource and its inherent characteristics, the impact of the resource on the well-being of the community, the scarcity of the resource, and the consequences of such a resource being concentrated in the hands of private owners. The dissenting judgment in this case was by Justice Nagaratna, who also wrote a dissenting judgment in the demonetization case, which, as you know, like by the time the court finally heard it, and as Gautam has described it, Gautam Bhatia, is the politics of evasion. Our court doesn't hear cases anymore till it's too late for them to really make a difference in their pronouncements. The demonetization case was also about the right to property because money is property. And insofar as the state really took away our ability to access our money, they took away our right to property. But the case was never heard at the time. When the case was finally decided, the majority said the government's actions were legal. I had taken a position even at that time that the government's actions were both illegal and unconstitutional. I was happy that Justice Nagaratna supported that judgment, supported that opinion in her judgment. And she was also the dissenting voice in the Mada case. So this is where we are, where we've kind of come full circle. And the question is like, we spent 2.5 years debating on the constitutional property. We adopt it, we keep amending it, then we get rid of it, then we bring it back. Like, what is going on? Why are we doing this to ourselves, right? So that is really the question. And that's where I want to really talk about the role that rights play, including the right to property, this very vilified right, where everybody was like, this is the villain in the story. But the role that rights play as a check on arbitrary exercise of power is in the case of dominant party regimes and authoritarian regimes. And I think you would all appreciate that this conversation, even though it's about history, is really relevant to the present, not just for India, but all over the world. So what happened in the 1950s? As I mentioned, these were the three different groups. On the left, we have Dr. Ambedkar, Prime Minister Nehru, and Sardar Patel, who had different views in the Constituent Assembly on what should be the way forward. So Nehru represented the Congress Socialists. Ambedkar was also socialist in his thought, but he was also a lawyer who was also someone who had faced as a Dalit so much discrimination and arbitrariness in society that he was someone who was balancing the needs for like socialist progress as well as like freedoms and democratic rights being the most effective check against arbitrary power. And then there was Patel, who had a more conservative approach and who was favoring property rights. But then Patel died, and Ambedkar, who was finding it very difficult to work within the cabinet. So this is a statue of Dr. Ambedkar that has finally been unveiled in the Supreme Court of India. And as I mentioned, what changed between 1951 and 1952 that Dr. Ambedkar actually, he's the one who introduced the constitutional First Amendment bill in the Constituent Assembly in 1951. In 1952, he was arguing against 31B and 31A and the Ninth Schedule in the Supreme Court on behalf of the Zamidars. And it's not because he suddenly like became corrupt and like he was being paid by the Zamidars. It's because he saw the danger, what was happening, that from 70% of the delegates in the Constituent Assembly, the Congress party was 90% by the time the constitution was drafted. And by the time the government was elected and they were going for elections, and also the fact so there was no, given a first past the post system in a parliamentary government, there's no real scope for anyone else to put their views forward. And the only way, therefore, for them to pursue opposition once the parliament has passed something is really to go to the courts. And we can see that even today. It's either agitation on the ground in Gandhian social movement-led style, like we saw with the Ekta Parishad seeking land rights, or the Adivasi movements and the civil society and the groups like these that come together and put these issues for the forefront, or to go to the courts. There is no effective opposition in that kind of system when there is a dominant party, as the Congress was from 1950 to 1967. And we were talking about Punjab I was talking with you about Punjab. In this case, in 1967, I.C. Golaknath was the state of Punjab, was really about the land reform law in the state of Punjab. So this was the second phase of land reform. So the Zamidaris had all gone, even though the court got a bad name, it really didn't stop the Zamidari laws. It was the next phase of land reforms, which was the land ceiling and land redistribution, where Golaknath took this case to court. And Justice Subba Rao gave the decision that fundamental rights cannot be, because by this time, by 1967, the constitution has already been amended 17 times. Every year, one amendment. Wherever they don't like what the courts say on any subject, they go ahead and amend the constitution. So by 1967, in Golaknath, this was the biggest bench strength till then. They said that the government cannot amend fundamental rights out of existence. They can't do that. And interestingly, this is a very turbulent political time. The Congress itself is going through this turbulence after Nehru passes about the succession to the party. And we can sort of relate it to present times where we have a leader who has been leading a party for a long time and there hasn't been gradual consolidation of power. And then there's this, disputes within the Congress, and ultimately the Congress splits in 1969. So that's when Justice Subba Rao gives the judgment in the Golaknath case. And then, this, like I said, there are many within the Congress party who feel differently about the way forward. And the Congress is kind of this umbrella party from which all other groups sort of came out, right? So these voices that they couldn't find their view forward because of the particular institutional design of our parliament, first past the post and other things. So the Congress splits. And the Congress I and the Congress O, and then Indira Gandhi, is the prime minister. She takes control of the Congress I, and then there's elections. She becomes the prime minister, and again, like there's this constant push that is happening. But the only oppositional voice once there's consolidation of power, once she becomes the prime minister, is again the courts. And then we have in the middle, you see this picture of Keshwanand Bharti. This is again a land case, which led to what is the basic structure judgment, the highest bench strength, 13 judges, where the court said that, well, Golaknath was wrong because there's nothing in the constitution which says that you can't amend fundamental rights. They haven't specifically said that. But seeing the threat of this dominant party government becoming more and more authoritarian, they said, well, you can't amend what we call the basic structure or the basic features of the constitution. And it's a wafer thin majority, 7:6. And then, the judges in the majority, they actually come up with different views on what the basic features are. And then after this, Indira Gandhi packs the court, Justice Khanna, and others who were in the majority, they are superseded, and she appoints the people in the minority to be the judges. And this clash is intensifying, and society is also getting very, very agitated because there isn't a way of presenting one's views. And finally, after the basic structure case, 1975, Indira Gandhi declares emergency and arrests the opposition, puts them in jail. And so now we have no opposition, right? And this is against this historical backdrop. I looked at all 377 Supreme Court and 1,239 High Court decisions on property. So a total of 1,616 cases involving a challenge to the right to property to really see was this court so bad? Was it really protecting the rights of the rich? Or, was it doing what it is supposed to do, which is really to protect rights against arbitrary state action? And my review shows that actually the court wasn't really disagreeing with Parliament on land reform. They keep saying that, yes, we need to go. But the point was that there was a divergence in views, even in the Constituent Assembly, even in government, as to what is the way forward for land reform. And there, and the court, if you go to the Kameshwar Singh Patna High Court decision and Supreme Court decision, when you compare the Bihar law with the UP law, the difference was the Bihar law had vested too much discretion with the people who are going to do the land reform as compared to the UP and the MP law. So it was a bad law. And the appropriate thing would have been just to refine that law, but instead they went ahead and, basically said that how can you question us, and got rid of, the judicial review itself by putting 9th schedule. And then it never stopped there. It didn't stop at land reform laws. They kept putting more and more laws in the 9th schedule, whatever they wanted to do, reservations, everything. The 9th schedule is now this big balloon of laws, where there's plenty of laws. So the disagreement, now that I've looked at 1,616 cases, is really on fear of arbitrariness. Court always defers to the government. They're never saying that you shouldn't do this with a broad scheme of social and economic welfare, but either the provisions of a particular law were found to be discriminatory without a rational basis, and or were applied in a discriminatory manner between similarly situated parties. So, for example, one of the reasons why I said demonetization was illegal and unconstitutional was in part because it discriminated between those who had bank accounts and those who didn't have bank accounts, because there were different provisions for who could access what kind of money. And given that not all Indians at this time of demonetization had bank accounts, it was a discriminatory provision, and it was also causing undue hardship. So these were some of the grounds the court has used in these decisions to disagree with a particular law. And even though there is a consensus in Parliament about the overall social goal, outside there is no consensus within Parliament about particular measures for achieving that goal. So the court serves as a site for mediating tensions between the majoritarian will. And remember, it's never an absolute majority, because we've never had a government who has had more than 45% of the vote share and yet have such a dominant role. But they're basically mediating tensions between this majoritarian will and the political opposition, which is ineffective in Parliament. So this is just to give you a sense of the cases, the claims that were invoked. The most invoked claims are obviously 19(1)(f) and 31, which is the right to property, but they also bring in equality, Article 14, the right to freedom of trade and business, and Article 19(1)(g), Article 31A, Article 21, the right to life also comes in, because a lot of these claims that they bring under property, they are also about livelihood, and they bring livelihood under life and property. And the interesting thing that I would like to observe here is that if 31 had remained in the Constitution, perhaps 21 would not have become so expansive, because actually they were bringing a lot of livelihood and other claims that came under life, under property. And therefore, I go back to the first slide on the many meanings of property and how we can, understand that. The purpose of litigation, you would think that, all this stuff about land reforms, that it's only 20% of the litigation. Most of the litigation that is coming before the courts is other areas. It's a big part of the litigation, 20%, but a lot of the litigation is about taxation. And I can personally testify to the arbitrary use of tax power to silence people. There's also during the emergency, there's import-export control orders. There's newsprint control, the famous Indian Express newspapers case. There's all kinds of cases that involve the right to property, and they're not really necessarily about obstructing land reforms. There are cases about licensing. We all know what's happening to licensing right now, how arbitrary power is being used. So religious property, resettlement of refugees, evacuee property, there's all kinds of claims that people are able to bring because the right to property empowers them to do so. And so that brings me to the conclusion. There's obviously a lot to be said about land, property, and democratic rights, but I'll just leave with a few thoughts that the Supreme Court and High Court's interpretation of the right to property was less about property entrenchment of the elites, more about rights and resistance against arbitrary state action in the context of a dominant party that later turned authoritarian. No right, in my view, and as the history has shown, has a settled meaning, but has to be understood within the broader operating discourses of the time and is open to development by various actors in different ways. In developing countries that are also constitutional democracies like India, the hegemonic development discourse often, but not always, trumps the rights discourse. The development discourse often privileges, because of the very nature of how development was conceptualized, the urban over the rural and industry over agriculture, and privileges property rights of industry over those of poor peasants, forest dwellers, traditional fisher folk, and other traditional communities. But the creation of rights is an empowering tool, which, when developed incrementally, as we have seen in India over time, has also led for the bottom 60% to develop their rights, not just as a check on arbitrary executive power, but also as a dignitarian manifesto for them to really assert themselves as communities and people with voices. So rights are super important for their dignitarian empowerment and other ways. And the meaning and content of those rights has to be developed incrementally and settled over time by various actors. So long as institutions remain independent and civil society remains robust and vigilant, the content of rights, as we develop it, can prove a significant check on executive power. And we should be very careful when narratives are spun about certain rights being and certain institutions, being reactionary, especially when they come from dominant parties that sometimes turn authoritarian. Thank you so much.
You're welcome.
We can take some questions, so.
Yeah, sure.
No, sit down, sit down. Just a minute. You will agree that this first hour was a very exciting and challenging hour. Not only because of, sorry. Switch off time.
Oh, sorry.
Uh,
No, that's off. So,
why is it?
mobile phone. That is, yeah. You're the one, yeah? House? Yeah.
Okay. Now, okay, let me speak. Let me speak loudly. I said it was exciting not only because of the emphasis on the bottom 60%. I think that is the reference point. And the rights have to be always seen in context. But several sort of thoughts which are very popular, she has put them in context and questioned them actually, and many new facts, of course. I mean that Ambedkar needed for commercialism, and that and it can be misunderstood, but again the context. And the context in several points of time referred to authoritarian behavior of the state. How it sometimes used populist propaganda populist majors to go ahead with its authoritarian agenda in many points of view. And I was fascinated by terms like emancipation from social oppression.
Yeah, political, economic, and social subjection.
Social subjection. I think that was not social oppression is very well known. Yeah, a social subjection. Yeah, I think that was a very, very fascinating concept. And there are many. I will not try even to summarize um, uh, and invite questions. You will please conduct the questions and then I will.
Do we have any questions? Just please be loud.
Basically, I have some few observations. You talked about Ekta Parishad. That's in the north or probably some parts of Maharashtra. But earlier to that, there were movements in Tamil Nadu, say Pachamani land movement, Dalit land right movement, and also Krishnamma Jagannathan, who inspired by Bhumidahan movement for Bhava, Bhave. And she started an NGO and she distributed 1,000 acres on her own. She mobilized resources to 1,000 people, 1 acre each. So we should, I think, cover that one. Secondly, you linked property and development probably, and after independence, is that the poverty index has come down. True. But the thing is, then if the poverty index has come down, when the government is distributing 18 lakh cards, which get 20 kg once free rice, if they are not living below poverty, and 55 lakh cards, PhD, that is 8 kilograms. And also there is Mahatma Gandhi Entrega program, which gives about food for work life. And I think they get very minimum 100 days only. But if you remove all that, I worked out it is 21% as far as Tamil Nadu is concerned. People living below poverty line. So when we talk about poverty index, we should take care of all this government's freebies, which is not productive. And maybe it's helpful because somebody argued also Amitya Sen was in favor of free distribution because that was help. Just give a pen so he saved him, right? Just give a shake. So he has come up with strategy. That's not the should not be the attitude. People should respect that they should have self-respect. So or the government should initiate schemes, can kind of they need not depend on them. They should be on the other. That is one. And then you talked about a lot of things about the economics as well as dialogues by the Constituent Assembly. But you have not thrown light on what exactly was discussed to have a 90-acre ceiling limit. What is the science behind it? Is there any? Because then they reduced it in 1972 from 90 to 45 acres. What happened? Why did they reduce it? If they had found that principle on some science or analogy, then why should they go back and reverse it up to 45 acres? So all that I thought.
We'll take a few questions.
Okay, we can take a couple more questions.
Yes, not.
Thanks so much, Namita. I had two questions. One is a methodological one, and the second is a substantive one, and the two are connected to each other. The methodological one goes to the heart of the argument, which is the counterintuitive, reconstruction of the question of the status of the right problem. And the way that we've done it is by moving away from the canonical kind of cases that we're all accustomed to note, and using a kind of a big data approach of looking at all some of the other kinds of cases, right, which we don't study or are historically discussed. Now, the question that I have then for you is this. It's very clear in terms of the benefit of hindsight that one is able to make an argument about the right to power. And that leads to the substantive question. The substantive question is, how do we understand then political critique as it emerges in the unfolding of a political moment? Right? Which is, if we were to look at the entire dispute between the parliament and the judiciary, going by the conventional narratives, which I have also believed in and also recycled, that this was a conservative judiciary, the parliament was trying to, the tussle between the two. let's take that turning point of the flashpoint of Kishore and Bharti, where Nani Palkiwala was the one person who was arguing that first they will come for your property and then eventually they come for your liberty.
Yeah.
Right? He was coming in from a libertarian position. He represented, the sugar barons essentially bankrolled the Kishore and Bharti case. Now, as a political observer and commentator at that time, I would have been very suspicious of Palkiwala, right? And so, how do we reconcile between this, where I can see exactly what you're saying in terms of the importance of it, which then comes to my final point, which is underlying the normative kind of argument underlying your presentation is a principled commitment to the idea of the rule of law and to the idea of procedure, which has been subject to absolute kind of destruction by someone like Narendra Modi on one hand, but also equally subject to critique by the left for their critique of this wishy-washy liberal legality, privileging procedure over substantive kind of questionable justice, etc. Right. So how do we reconcile between being political actors in the moment, having to take kind of normative political evaluations versus a retrospective understanding? And is the solution in your case reconciled with a principled commitment to the idea of proceed?
Sure.
ममता जी हिंदी में पूछ सकते हैं तो मुझको लग रहा है कि फाइंडिंग आपका है करती है अदालतें जो मनमानी कर रही थी दिखाई था उनके इस 16 जजमेंट आपने पढ़ते उसमें वो अपने जजमेंट के माध्यम से और क्या लगा उदाहरण सकते हैं जैसे आपने बताया कि डॉक्टर बेकर कैसे बदल गए तो उनका कमिटमेंट नहीं बनता लेकिन उन्होंने ये देखा कि ये कार्यपालिका की मनमानी लेकिन उससे वो सवाल शुरू हो जाता है राइट प्रॉपर्टी का सवाल शुरू वो इंटेंशन हो जाता है कि कार्यपालिका सरकारी इतना नहीं करो या तो उसके अंदर में भी कुछ प्रावधान होंगे तो आप जजमेंट का बाद में रिफर करती है सरकार को जिनको अगर आप सब 16 से 16 में तो आपने बनाया वो चार्ट बनाया तो उसमें कई दक्ष एक आपके बिजनेस का सबसे बड़ा आता है कई छोटे छोटे होते हैं क्योंकि आपने उसके बाद ये भी कहा आज के समय में भी अलग अलग कानूनों के माध्यम से हमारे अधिकारों को रोका खास करके टैक्सेशन में अब वो पीढ़ी का आ रहा है या मतलब उस माध्यम से आता है लेकिन क्या इसके माध्यम से हम लोग कह सकते हैं बता रहे हैं कि एक और अंत में आपने कहा कि चूंकि 21 खत्म हो गया इसलिए 21 के अंदर हमने डाला राइट लाइफ के अंदर में हमें सारा मिला तो आप ये भी आगे करना चाह रहे कि राइट जगत की संविधान में और उसका उल्लंघन कुछ नहीं आप ये कह रहे हैं
ये तीन क्वेश्चन पहले ले लो।
Yeah, otherwise I'll forget. Thank you. Thank you. So first to the lady here. Thank you for your observations. Obviously, there is a lot to be said for all the states of India. There were many organizations. This is just a snapshot of the movements and the discourses that have influenced the, the incremental development of property and rights and development. So I completely agree with you. The land ceiling laws, so it was not a debate in the Constituent Assembly. This is the second phase of land reforms. So in the Constituent Assembly, they're just talking about abolition of zamindari. But land ceiling, and there is the planning commission, it comes up with certain guidelines. Each state has a different ceiling. Though that case was really a case of land ceiling, where it was a question of, okay, 10 acres is the land ceiling, but it was a question of whether it applies within a family so the law said that the sons it applies to everyone within the family, and it was challenged as being unconstitutional because it was discriminating. Like if a family had 5 sons, they have only 10 acres, and if a family has 2 sons, they only have 10 acres. So it was an individual discrimination. So yeah, I don't think that there was a lot of scientific sort of determination. This is what I'm saying is that why is there so much conflict over the right to property? It's not because they're not intelligent people who can't get it right. It's because it is such a politically and economically controversial thing. There are multiple stakeholders exercising their views, their voices, and which is why we need, and I'm so glad that you mentioned the bottom 60%, because I do want to highlight how important and how empowering every right is to people who have been socially subdued, and how important the right to property has been for women as much as all the other rights have been, and for Dalits and for Adivasis and so on. Is so that is really the narrative and the story is really about that. As regards, I mean, of course, there are huge inequalities. There is a lot of questions about how many people actually are in poverty, but there can be no dispute that we have lifted a tremendous number of people out of poverty. And I think that is something we should be proud of. And I do think that there is a tendency sometimes on the of critique that we just dismiss everything. No, we have done some great achievements and progress. We have gotten rid of starvation, famine, etc. Yes, we have a lot of people who have now emerged above the poverty line are very precarious still, and those are the things we need to work on. But that's very different from the kinds of challenges Nehru and the first cabinet and others were facing. We have come a long way, and Lawrence, of course, this is such an entrenched narrative, right? And it always raises eyebrows when I say it. And you're absolutely right. So my own view of rights is that there is, and that is the leftist critique, right? That which was what Marx and Rousseau were saying, that when you speak about, I mean, in his essay on the Jewish question, Marx is saying that right to liberty is only protecting the liberty of the propertied, right? And that has been the left critique. And I see the valence of it, but I do not agree with it, because I do think that rights are intrinsically both dignitarian and empowering, and the rule of law and procedure is really important, because unlike Marxist understanding of the superstructure, and it was a class-based analysis, Dalit, and the reason why Ambedkar, the reason why he moved away from the socialists, like if you look at his early writings, he was very much with the Congress socialists, and others were writing, but he quickly realized that they were only focusing on class and not on the social subjection of caste and so on. And which is why he's such, apart from, why he is so important. And even though Gandhi and Ambedkar didn't really see eye to eye on many issues, I do think they were two of the most significant people who had an understanding of what social subjection was in different ways. And they had different ways because they had different goals, really, for what they wanted to achieve. But, going back to your point about a political commentator at the time, I want to highlight, so, judges are not experts in particular areas. What they hear are the cases that come before them. And in 1951, when they passed the First Amendment, it did not only restrict property rights, it restricted free speech. And each one of these amendments, and so they're not just hearing property cases, right? They're hearing free speech cases, they're hearing other cases, they are seeing what the government is doing in a way that, people who are only looking at property are not going to see it. But they are seeing this gradual encroachment of power. I mean, look at in the 1950s, look at where we are. The RSS was banned after assassination of Gandhi. So a big voice of opposition. In my chapter in the book that I'm working on the subject, I have this chapter on the evolution of the right to property before the Constitution. And I talk about the important role of the Hindu Mahasabha and the Muslim League before the Constitution. But then the Muslim League sort of goes off to Pakistan, so they become less relevant. And then the RSS is banned. So and then Patel dies. So where is the opposition left? And if you read Ambedkar's letter of resignation in 1954, he makes this point very clear. I mean, it's a very important document. I think everybody should read it, about what was his main concern about the fact that, he not only was he being sidelined, I mean, he was a law minister, but also the social subjection narrative that was critical to his thing was really not moving within Parliament the way he wanted, because a lot of people in the Congress party were very conservative, were representing a lot of those voices. Coming to Indira Gandhi's time in Nani Palkhiwala, so I think there were enough people talking about, if you look at the criticism that Indira Gandhi got from the people who then became the Congress oath, they were criticizing these elements. And Trump is very popular today, but Indira Gandhi's rhetoric was very populist. The abolition of the privy purses really was not going to make too much of a difference by that time, because of the graduated scale of the privy purses. Very little money was going to the part of the privy purses. But these were like these big flashy moves that you can make, and I don't think that it was good as populist rhetoric like Garibi Hatao and the focus and all that. But I think she was fundamentally not someone who was really taking oppositional voices into account. And to that extent, I do want to say that, it's whenever the rights of the elites go, the rights of the non-elites also go. And I think that is something that, while taking the point of the left critique, that is something that, is something I personally believe that procedure rights are super important because we just don't know when. And again, I want to bring my attention back to the institutional point that we are in I'm making this point not about this history, but about the future as well. The seeds of authoritarianism are very much within a parliamentary system with a first past the post system. And over time, if we see, and that's the subject of a different talk, but even within parliament, the ability to question has been taken away. Within political parties have become authoritarian. So there is a sort of tendency towards growing centralization of power within political parties, within parliament, the kind of questions that can be asked. There's a lot of changes that have happened over time in other institutions, not just with the court. And I think that's what we ought to be paying attention to. Sorry, your last point was really that if I believe that the right to property could have really been an umbrella for various kinds. Of course, for example, I'll give you two examples. The state of this case that I really like, which I used for my point on demonetization as well, is Sagir Ahmed versus state of UP. The government of UP had nationalized road transport. Excellent objective, court agrees with it. The people who brought the case to court were the bus owners and the bus operators, the drivers. Because what the government did, and this is the problem with our government's laws, right? That they nationalized road transport, but they didn't buy the buses of these people. So suddenly they're saddled with their buses that they can't fly. They've lost their jobs. They've lost their thing. So the court actually gives its judgment on the right to livelihood of the bus operators as well as the right to property of the bus owners. So, and there are many such livelihood claims that come up. And all they say is like, why did the government make this ham-handed? Why couldn't they just buy the buses and give some compensation to these people so that they could form a different way of life? And we see this across judgments. We see this in licensing cases, Essential Commodities Act. Government takes over, the ability to sell an essential commodity, but then nobody's left with any compensation. And that's not really an eminent domain case, so you don't have to give compensation, but it is causing a lot of hardship to the people who are affected by these orders. And a lot of these are executive orders under an existing law, which is a British law, which is a colonial law, which was anyways a more draconian thing. And we're just continuing like this. So,
Okay.
so yeah. Sorry, the Essential Supplies Act was a British law.
My question from the is what you say, because there that start guarantee of 60% without that. Now you can say Constituent Act would give ownership. 75 if you argue that all not protected section would get the right to have a tilling of the land, ownership of forest, ownership of mine. That's one thing, but that won't come under the notion of 31. That the issue.
No, but in the land reform cases, and this I think responds to Lawrence's point as well, I'm not just doing a big data kind of analysis. I have looked qualitatively at those cases as well, right? And I said it, that in the land reform cases, the court actually upheld all the land reform cases. So I don't know why, because I don't know, it's not even about looking at 1600 cases. Just look at all the land reform cases. There's like, it's not a question of like the court opposing the government or land reform. No, any case where the government opposed, if the court has intervened in even one case where there is clear arbitrariness. So, for example, the Rayat Wari, when they moved to Rayat Wari tenures, they passed this law that certain plantations would be exempt. So they said coffee, cardamom, and rubber, and then there were like two other plantations that were not exempt. So they went to court and said, why have you not exempted these two plantations? And that's why the court strikes down that provision in the law. Not because they're against the law. Nationalization of banks, they go and nationalize the biggest banks. But then again, the question is, why didn't you nationalize everyone? And of course, you can make an argument as to why you didn't do it, but often there's no scientific basis, as you said, as to what the land ceiling is. And so the court is simply asking the government to explain. And unfortunately, a lot of the times the government is not able to explain, either because they don't have the capacity or the willingness. We don't know. We can't tell from the judgments necessarily. They don't show up with any arguments. And the court is supposed to respond to arguments. And so it says you have no basis for your discrimination. So we don't, you know,
There is one question.
Yeah, Param. We start with Param.
Uh, I was just looking at the, various land reform that Punjab actually. And one is major, there are two major actually, one is 52 and one is 72, essentially. Which earlier was 35.3 acres of land and then we reduced to 17 point some acres of land. Although there are different grades in that, the type of land. People are aware of that. So I was just referring to the various land ceiling acts, which is from Punjab actually. One is 1952 and one is 1972. Earlier it was 35.3 acres or something like that, or in
25 acres.
in 72 it came to
25.
17 point something.
The standard acres. So
Yeah,
you
standard acre.
convert it into normal acres, it's 45.
Okay. So, but going all this, I never seen any act which is talking about a landless, this only talk about the farming community, the landed community, or even the tenancy act which came was also for those who were tenants. But it never talks about the landless, the peasants for them, or even the workers. So till today, there are so many laws, so many acts which have come. Apart from the 1961, I think it was for Dalit community that 1/3 of the land, the panchayati land, could be, during auction, which is reserved for the Dalits. That also never, happened in such a way. But in 72 Act, I have seen that the surplus land to be distributed among landless and the Dalits. These both terms are there. Apart from that, if you can throw some more light on that about the landless language of it.
Just a small observation.
Just one.
We'll come back.
We'll
We'll
come
come
back.
Some Mohanty.
We'll come back.
Okay.
Anushka.
Hi, Namita, thank you so much for the presentation. I'm going back to some of the questions that were asked. So,
yeah.
So on the one hand, there is this claim that almost all the land acquisition acts were upheld by the courts. On the other
Land
hand,
reform.
sorry,
The Zamindari abolition laws and most of the land reform laws.
on the other hand, there is this tussle on the question of property, which portrays a certain image of the parliament and portrays a certain image of the court. My question then is one that what is the material basis for this kind of the narrative to emerge if the land acquisition acts are not really the heart of the matter here? That's one. Second, so from the presentation, it seems the preoccupation of the courts is really the procedural violations involved, or the undue nature of the implementation of these acts. Is the court, outside of the procedural concerns, invested in the content of the right to property? And we go back to the question, the slide with which you began your presentation, that there are multiple meanings of property. So when the court is adjudicating on the question of property as a constitutional right, there is a prior concept of property with which the court is working. And I'm not sure whether the Constitutional Assembly had clarity on and from what one reads in Austin, it was the happy and unhappy compromise between the Liberal Democrats and the Socialists. So there wasn't really a clear conception of property. In the course of the adjudication, outside the first question, what is the basis for this narrative to emerge? The second question would be, in the course of the adjudication, are the courts really devising the content of the right to property, which is in sync with the constitutional vision of India? That's the question.
Two observations, sir.
There are some more people.
No, just a small one. Because when you mentioned the common land, in the list, there is no such common land.
That's not
There is
true.
Dalit area and the caste Hindus. So the caste Hindus own all the common lands. So that you should clarify. Also, you said that people, no, also you said that the poor people are encroaching. But in the contrary, rich people are encroaching.
That's true.
Not poor.
He didn't say.
Poor people are considered as the encroachers by the state and the rich people. Okay, that's how.
मेरा पंजाब के संदर्भ में लैंड से जुड़ा मामला है सवाल है कि जो राइट का जो सवाल है राइट्स के इशू को बात कर रहे थे मुझे लगता है कि राइट टू रिकॉग्निशन और का मामला प्रॉपर्टी से जुड़ा हुआ है ये स्टेट कैसे एक वर्ग के प्रॉपर्टी को रिकॉग्नाइज करती है और दूसरे को रिकॉग्नाइज नहीं करती है जैसे पंजाब में सम्मिलित देहात का मामला है जो पंचायत की जो जमीन है जिसपे स्टेट ने लॉ बनाया और अभी तक कोर्ट ने उसको रिकॉग्नाइज ही नहीं किया ये दलित की का लैंड तो स्टेट कैसे डिस्क्रिमिनेट करता है एक वर्ग दूसरा इससे बड़ा डिग्निटी का भी सवाल है कि राइट टू जो लैंड का इशू है ये दलित और वीमेन के लिए डिग्निटी का इशू ज्यादा है और जो बड़े लैंडेड एलिट है उनके लिए अभी के संदर्भ में ये इन्वेस्टमेंट का मामला है तो ये स्टेट यहाँ पे और इनफैक्ट कोर्ट भी डिग्निटी के इशू को उस तरीके से खासकर दलित और महिलाओं के संदर्भ में डील नहीं करते लैंड को लेकर इशू को
We can take just one more question.
Here, that's one. Can you pass?
मैम के क्वेश्चन आगे बढ़ाते हुए आपने मैम क्वेश्चन का आंसर दिया था मैम ने पूछा था कि इंडिया में अराउंड 80,000 पीपल जो नहीं करोड़ 80 करोड़ लोग जो हैं वो गरीबी के अंदर आते हैं तो आप बोले मैथोलॉजी क्या है क्या आपके डाटा दे रहे थे उसका आपने आंसर दिया था कि हमने काफी लोगों को गरीबी से बाहर निकाला है तो ये कमेंडेबल स्टेप है बट इसी को देखते हुए जो मतलब सारे पॉवर्टी को लिखने वाले ऑथर है वो यही करते हैं अनुचित कृष्णा के खिलाफ बोलते हैं बोलते हैं आमतौर पर जब हम पॉवर्टी को देखते हैं तो हम ये देखते हैं पॉवर्टी से कितने लोगों को बाहर निकाला है उनका राजस्थान के ऊपर एथनोग्राफी स्टडी तो वहाँ वो दिखाते हैं हम ये नहीं देख पा रहे हैं कि कितने लोग पॉवर्टी के अंदर चले गए हैं जैसे मैरिज होता है वहाँ बहुत लोग खर्चा हो गया उनके ऊपर लॉन हो गया है किसी को हेल्थ इशू आ गया है कहीं कोई आपद आ गई इस वजह से काफी लोग पॉवर्टी के अंदर जा रहे हैं तो पॉवर्टी नॉट वन डायमेंशनल की हम बाहर ही निकाल रहे हैं इट इज टू डायमेंशनल कुछ लोग अंदर जा रहे हैं तो कुछ बाहर आ रहे हैं जैसे वो डाटा देते हैं राजस्थान के अंदर 27% लोग पॉवर्टी से बाहर निकाले गए ऑन द अदर हैंड 21% जो वापस पॉवर्टी में चले गए तो जो ओवरऑल लोग पॉवर्टी से बाहर निकाले गए 6-7% था तो ये डाटा मतलब मेथोडोलॉजिकल मेरा क्वेश्चन है पूरा
Yeah, you have a question. Last. Please ask. Just be loud.
I have just an observation. While talking about Ambedkar, you didn't highlight the fact that it was the same Ambedkar who, as a representative of the All India Scheduled Caste Federation (AISCF), presented a document called the States and Minorities, where he spoke about the nationalization of property and industry. So you highlighted about his about him being the lawyer of Kameshwar Singh, but there was this side to Ambedkar also with like what the document which he represented in the Constituent Assembly itself. So that's just an observation.
Okay.
Okay, those are my questions. So I think the broad response to your question about Punjab, and I think there was another question about Punjab. I mean, that is what I'm saying that. So first of all, there were 5 stages to land reforms: abolition of zamindaris, land ceiling, land redistribution was supposed to be one of the phases of land reforms. Sorry?
Consolidation of
Consolidation of land holdings, tenancy reform. So, 5 stages. And if you see the mapping in the land laws website, we have laws for all of those 5 stages, right? And it would be interesting because Punjab is one of the states for which we have the laws on the mapping in the land laws website. So you can actually search also within the website for those laws and see, what laws did talk about redistribution and consolidation of holdings and why those laws are not implemented. And, a lot of the times, so when we were building this project, because like I said, it's such a vast subject and, anyone here can come and say, oh, you didn't speak about my state. And, but there are so many states and there are so many laws. And that was the point of the project. And it is unbelievable that nobody had done this in 75 years, right? So, so and under the laws, there's like delegated legislation, which we've never reached that point yet. And actually, a lot of the implementation of the laws, because a law can be passed, but the way it is to be implemented is done through that delegated legislation. So, the two laws that we're talking about, I would encourage you to look at what they actually notified under that law and what they are doing under that law. And I think that when we were doing so, one of the states in the website is Assam. And when I remember when I went to the Assam Land Revenue Department, they actually gave me only 10 laws. The rest of the laws, because we followed a process of speaking to different, professors, lawyers, who told us about all the other laws. So the state actually often is not even aware of the full gamut of laws. They only use the laws that they need to use, right? I keep emphasizing this again and again that it's a post-colonial state. They have 150 colonial laws that are still on the books. And the Land Acquisition Act, which was only repealed and replaced in 2013 after 120 years. This law was from 1894. And, these are the laws that they are applying. As regards, and I think Lawrence also connects to the point about narratives. And, this is most people are often shocked by what I say because it's so counterintuitive to what they've studied or known and so on. I think I've been in the policy space for the last decade, and I have seen very closely how narratives are built. So, for example, when I moved back to India and set up the Land Rights Initiative, the first reform of the Modi government was actually on land acquisition. They wanted to amend the right to fair compensation and transparency land acquisition law. And one of my colleagues at CPR at that time was Dr. Rajiv Kumar, who went on to then become the chairperson of the Niti Aayog, the vice chairperson of the Niti Aayog. And I remember the time there was this narrative that was being put out by every single government official I met and him. And they were just like, this new law is going to stall all development. So I kept asking them, I said, where is the data? But they had no data in response. But these are powerful people who are able to say things that create narratives in government. And so that's what actually led to the land acquisition report, because when I looked at the government websites, there was no data on how much land has been notified for acquisition, nothing. So, but where do you actually get data is from the courts, because in the courts are the only places where the government actually has to justify what it's doing. And, and that is something intrinsic. So I was talking about the intrinsic nature of rights. I also want to talk about the intrinsic nature of courts, because in courts, the government becomes an equal actor in a way with the litigant and has to put forward a justification for why they're doing what they're doing. So I built the data and I was able to show that actually land acquisition law, the one that was passed, would be useful in translating on-ground conflict. Because, and I say this again, wherever you have rights and you are able to enforce them, it helps to mediate the conflict that is then going to erupt otherwise on the ground. Because what are people going to do if you take away their land? They have nothing else. So they have to fight. But if you give them rights, that doesn't go into violence, violent struggle. It gets mediated. And if you don't give them rights, it never gets mediated. So I think, being in the policy space for the last 10 years, I would say narratives are very easy to create. And there are not enough, there's not enough research. And for that, I would blame, the researchers, our peers, but our predecessors. Why have these things not been done? I don't know. Like, why couldn't they create a map of the scheduled areas? Why couldn't they build a land laws website or any other laws website? I ran this series on legal history at the Land Rights Initiative, and we had a talk on the new criminal codes. And Sri Singh, who gave that talk, he said that, in Bengal, for example, the police officer, the form that he's using to record a complaint is based on the Bengal Procedure Code, not even the Criminal Procedure Code of 1973. So the translation of the laws to the administrative practice is so archaic, in land also, and they may have passed the RFCT LARR Act, but if the government, they spent all their time trying to amend the law, the state governments, And, through delegated legislation, they try to eviscerate the content. And otherwise, they don't train their people to apply the law. So, I mean, I was in Labasna in workshops where there was a complete resistance, and government, a post-colonial government, which has not had to justify to anyone what they're doing, is very loath. So they've resisted implementation of RFCT LARR. They've resisted implementation of the Forest Rights Act. They've resisted implementation of anything that takes away their power. And the narrative, and so I don't know, there was an op-ed just 2 days ago about this forest department official saying FRA has destroyed our forests. And, and that has been the narrative that I've heard ever since I set up the land rights initiative from the forest department, that they have destroyed. So narratives are very easy to build in support of the government.
Brief.
Yeah, briefly. Okay. I think a lot of things are observations. A point about mentioning Ambedkar's work as states and minorities. Obviously, Ambedkar's body of work is not the subject of this talk, and he's done so much work on so many different subjects. And he was the chairperson of the drafting committee, so his vision and is what imbues the constitution. Yes, I think that we are seeing a complete fusion of the current discursive space on land policy. I mentioned a few of the initiatives. The Swamitva digitization app is all about digitization, geospatial mapping, and so on. And it was all done with the view that we are going to give property cards to people. And yet, I have been in consultations on the Swamitva scheme. We all said it was a consultation where we all said that if you're really going to do this kind of exercise, why don't you put in every case the woman's name on the property card? Because that will really, agar karna hi hai, so do it properly and give rights to the women who have not been empowered, but they didn't accept that recommendation, right? So, and then with this Swamitva scheme, the fact that this geospatial mapping is happening. So I've constantly been asking the government, if you see the data, they only have records of how many. So the principle behind this scheme is the De Soto principle, that, if you give these property cards, you'll be able to access financial resources. So, for example, if a daughter's wedding, and it's true, daughter's wedding and health expenses are the two biggest reasons that push people into poverty. So you can access a loan, but they don't have. So they have all this data about how successfully they mapped everything and how many cards they've distributed, but hardly any data on how many people have been able to access loans, because it's false. It's a myth. Banks do not give loans to people just because they have a property card. They give loans to people based on their ability to repay the loan, which they assess using a variety of factors. But why are they doing this? Is because, and now they've finally come out with the truth of it, is that they've created these technology hubs so that people will be able to trade in this data. So it's not about giving property cards to people. It's really about monetizing data on all of these things. But that is, again, the subject of a longer conversation. I don't think the point of the talk was really not about how many people we pushed in and out of poverty. I don't think there's any dispute about the fact that 75 years ago, the numbers of people who were below poverty line and the numbers that we have today, there is a significant difference. And I mentioned that repeatedly, that they may be fragile, but there's definitely been a lot of improvements in poverty indicators. But what I mentioned crucially was the fact that in the same period that the right to property was removed, because the right to property, and that was the narrative I was contesting, that the right to property was seen as preventing government efforts to pull people out of poverty. But as you also mentioned, and a few other people also, nothing stopped the government from redistributing land. Yet successful land reform only happened in 3 states, like Kerala, Kashmir, Karnataka, some of the most successful states. But in most of the other states, the redistribution part of it to the landless, to the Dalits, to the women, never really happened. And even now, as I said, in the Swamitva scheme, they're not putting women's names on the property cards, and they very easily could have, because they're doing this giant exercise. So, I think that is all.
Yeah.
And I do think that corporates are definitely driving the agenda now in a very big way, because, and I want to mention this, is because of liberalization, foreign direct investment, because I was trying to connect the dots. I was the property prices in states like Delhi are so, places like Delhi, Mumbai, they are so high that the people who live here can't afford them. So I started digging. And then I learned that there was this rule that, liberalized foreign investment in real estate. And that what means is that now we're not only dealing with our own capitalists, we're dealing with foreign capital. And so because this money is coming in, it has to go somewhere. So you have to grab the land to build these things. We are like Raipur, for example, in Chhattisgarh, where we have so many buildings and nobody's living there. There's no demand. but real estate is being created and so on. And if you remember from the election bonds decision, the 25 major election donors are real estate, mining, and infrastructure companies. They are overrepresented in the top 25 compared to any other category. So I think we know how things are working.
Thank you. Thank you very much. Oh, I know. Our time is up. I'll just make three quick comments. I think the land reforms agenda in a democratic rights framework has to be understood, and we have to build up a narrative on that. World Bank's land reform agenda was very different, as the point out. So we want land distribution, not symbolically, but every household getting a viable land unit. Many, there was a land law, tribal land bought during the last 20 years or so, it was returned. Now, they had no water, no other access to inputs and so on. They sold it back often to the same people whose land they had taken. In other words, you have to make land reform as a part of a viable agricultural livelihood sustenance strategy. That is number one. That is how land reform becomes part of a perspective where land right becomes a democratic right. That's number one. About the procedure and substantive, I think we have some very interesting formulations, but that land reform was one of the 20 points during the emergency. You see? And she pointed out that actually throughout this period, courts, probably she's right, I think that was contested by some. Courts raised questions about procedure rather than substance. Courts did not stand as a big obstacle to land. I think we have to have a balanced view here. Both are important. Procedure is important, but substance is equally important. Emergency was not the right way to carry out all the 20 points which were great, you see. And they became, in fact, delegitimized. Some of those 20 points were so good, but they became illegitimate because of the emergency stance. That's why they have to be part of the people's movement, becoming a law, then people's groups and bureaucracy working together to implement that law. And there are checks to see whether the law, like FRA and other right-based laws, which this regime doesn't own very much, not very much, doesn't own at all, how to really implement those laws. So, rights are not a legislation, and we have this debate was rights. Democratic rights perspective has to mean that package, that context. Finally, this narrative, development versus rights, development versus environment. I think we have to question these narratives fronted. The rights are the definition of development, fulfillment of basic rights, Dalits, women, right to education, right to information, right to food, right to employment. That is the way to define development. And just as protecting nature should be the way to define development because of the organic harmony, organic interdependence between nature and other species. That's what we have to intervene. Unfortunately, the media and the neoliberal media today has a very different agenda. But I think PUDR has a role to play. And thank you for contributing to challenging this narrative and creating a democratic rights narrative most strong. Thank you very much.
Thank you, Dr. Montgomery. Thank you, Dr. Wahi. We have tea outside, and Dr. Wahi will be available for any further questions as well.
Thank you. Thank you very much.
So much.
I must give copies of papers. Yes. Even I have.